Welcome back to the PI show. Before the break, we were talking about juries and the role of juries, but the starting point is, as Martin says, you're at home and you get a letter in the mail.
Yes.
And that contains what's called a jury notice.
Yes. You're required for jury duty, and you have an ability then to say, well, you can make an application that you are unavailable because of hardship, some of the things we just
You're
discussed.
overseas.
It's essentially a questionnaire, isn't it, Marty?
Yes.
And
Yeah.
they ask you a host of questions.
That's right.
And you can exclude yourself at that point in time.
You can seek to be excluded.
Excused. And then if you don't do anything, then you're obliged to turn up on a particular day. You're put into what's called a jury pool room.
That's right.
It's not a billiard room or anything. No, it's a jury pool room.
There's enough people to go around.
And then let's say then you're selected to sit on a jury. The judge then explains the role of a jury.
Yes.
As I say, usually, my experience, they're given a pad and a pen, and the judge explains what role the jury has in the trial, and then the barristers get up and the plaintiff barrister then opens the trial. And at the end of the evidence of the plaintiff, the defendant can get up before a judge and say that the plaintiff's case should be dismissed because there's no case to answer. And that's a question for the judge.
Well, Harry, I mean, the defendant can do that at any time. They can do it at the end of a plaintiff case.
At the end of the plaintiff's case, let's say you've reached the end of the plaintiff's case, the defendant gets up and says the jury should be discharged, this case should be dismissed, and it's the role of the judge, not the jury.
There's not enough facts there for a jury to find that there's negligence.
But the jury's got no role in that.
No. In fact,
it's a question of law.
In fact, they're taken out of the courtroom so that there's no bias or prejudice.
I think that's correct.
Yeah.
So they leave the courtroom, and then there's legal argument before a judge.
The judge has to rule.
And the judge the rules.
What's happened to them?
And what happens in a case where the case is continuing before a jury, and then the defendant in cross-examination asks some sort of questions about, let's say, your criminal past. It's a personal injury claim, but 10 years ago you were charged with rape, and the defendant lawyer asks the plaintiff about some sort of criminal charge. What happens then?
Well, if the plaintiff was acquitted
of rape,
it could be a very prejudicial question. So at that point in time, the plaintiff barrister would stand up and say to the judge, probably make application over the jury discharged, Harry.
So the jury can be discharged in the course of running a trial?
Yes, so he would get up and object. I would have thought the jury would be taken out to the jury room, and then the legal argument would be before the judge as to whether that was prejudicial. If the judge finds it to be prejudicial, he can discharge a jury.
And then the trial just continues on?
With the judge alone.
With the judge alone. So a jury can be discharged in the course of running for legal...
Well, it cuts both ways, because if a plaintiff barrister says something about insurance, you'll find the defence counsel might stand up and say, I want to make application.
Yes.
So if the jury's made aware that there's an insurance company sort of standing behind a defendant...
Could be prejudicial again for the defendants.
Yeah, so...
And there can also be the one where you've got contractors, employers, occupiers liability, which means it's at a factory which somebody else rents, and then you've got contractors come in, a normal thing which can occur in many workplaces. Sometimes the judge says, this has got complex contractual issues in it. I don't think it's appropriate for a jury to hear that matter any further.
So the jury again can be discharged in the course of running the trial.
Yes.
And also, as you say, the jury can be, if there's objections, the jury can be asked to leave the room.
They're generally asked to leave because they might...
And there's objections about evidence and about relevance and things like that.
Correct.
So the jury's sort of often in the dark about what the legal issues are, but they're ultimately to determine what the facts of the case are.
Yeah, the interesting part about a jury trial is the judge gives them an opening, as you said, and explains how the jury operates and what their task is. Then the plaintiff counsel gets up and tells the plaintiff's case, or takes the plaintiff through the evidence. Then there's cross-examination. Then the defence get up and they go through their evidence, and there's cross-examination. At the end, when all the evidence is being considered, the judge does a final address to the jury, setting out everything that's occurred in the court, and then gives them their task to go and consider.
Well, it's the judge's summary of the evidence,
yes,
which can be slanted.
Well, it's his address to the jury.
The address to the jury, and it's all on transcript.
Yeah.
So it's something that can be subject to an appeal by either party. So the jury's role is to decide the facts, but in effect the jury's role is to give a verdict in the case.
Correct.
So the verdict in a civil case in personal injuries is, the first question is, usually in my experience, was the plaintiff negligent? That's the first question.
Was the defendant
was the defendant negligent? Sorry, was the defendant negligent?
If the answer is yes, you'll find that there's always a second question.
Second question?
Yeah, was the plaintiff contributory negligent? Now you got me going, Harry. Was the defendant... Sorry,
was there
the
any contributory negligence on behalf of the plaintiff?
Plaintiff. So what was the plaintiff at fault?
Yes.
And if so, what percentage?
They apportion blame.
What percentage? So the employer might be 70% to blame, and the plaintiff
maybe
30% to blame. So that's one. There's two questions. And what's the third question?
The third question is how much? How much do you award this person for the injuries? And usually they break that up too these days.
Yes.
I've seen it broken up quite a few times where they break it up into general damages, which is pain and suffering and loss of enjoyment of life, and the second part is special damages, which is loss of income. And in public liability cases, medical expenses as well.
Yes.
So the jury is directed by the judge to answer questions,
Yes.
which is in effect the verdict.
Yes.
And then the verdict determines the issues in the trial, if you like.
Assuming, can I throw this one at you? And I get this all the time from various people. Someone said something in court and someone stands up and objects, and the judge says to the jury, disregard that response or strike that out. That will be stricken from the record. How effective do you think that is, Marty?
The judge, well, first of all, both barristers will have an opportunity later in the proceedings to address the jury as to that question and answer, and then the judge will also address the jury as to that question and answer. They will tell them to forget it.
Do you think they forget it if it's of significance?
It's very difficult to answer.
Yeah.
Well, I think the jury's handbook says the jury is to exercise common sense.
Yes.
And you hope that the jury selected at random does exercise common sense. I think that's all we've got time for in this segment. We'll come back to the further conduct of jury trials and see you after the break.